Wondering how Senate Bill 1968 impacts open houses? You're not alone. We'll break it down in simple terms right now. Let's look at the impact of Senate Bill 1968 on open houses by analyzing the three common scenarios. The first scenario is when you hold an open house on behalf of your own client. The second scenario is when you hold an open house on behalf of an agent within your same brokerage. The third scenario is when you hold an open house on behalf of an agent that's in a different brokerage. But before we jump into those scenarios, we first have to understand the fundamentals of what Senate Bill 1968 actually did. Now, this video isn't intended to go into all the details. We'll only set the stage as it's relevant to open houses. The first thing we must understand is that Senate Bill 1968 added Section 1101.562 to TRELA, the Texas Real Estate Licensing Act. In that section, it created an entirely new non-representation status. For the first time under Texas law, you can show a property without representing the buyer or the seller. Now, this is a sea change in Texas practice. Before this bill took effect, you had to represent either the buyer or the seller. In many cases, a default relationship was subagency. Now, you've probably heard about this bill being called the subagency killer. We'll go through how that isn't entirely accurate. It did kill it for all intents and purposes on the buyer's side for residential real estate, but it still may be lurking around in other areas. The second thing that Senate Bill 1968 did was added a written agreement requirement with residential purchasers. Section 562 we went over regarding non-representation status applies to all types of real estate, commercial and residential. The written agreement requirements of 563, on the other hand, only apply in the residential context, and specifically with residential purchasers. Now, the written agreement requirement can come in two different forms. The written agreement can be a representation agreement, or it can be a non-representation agreement. And there's different requirements that apply to each. There's a timing aspect of this too. Section 563 added trigger points that say when you must enter that written agreement with the prospective buyer. Now, for non-representation showings, that agreement must be entered into before showing the property to the prospective buyer. And you can imagine how that might impact open houses here shortly. The second trigger is if you never show a property to a prospective buyer, you must enter the written agreement before submitting an offer on behalf of that buyer. And the third trigger point is if you first do a non-representation showing and you have a non-representation agreement, you must enter into a representation agreement before you do any other act of real estate brokerage on behalf of that buyer. Now that we've established the foundation of what Senate Bill 1968 did, let's look at our scenarios. The first scenario is when you're holding an open house on behalf of your own client, the seller. In that case, the rules are very simple. First, you must inform all prospective buyers that come to the open house that you're there representing the seller. Fortunately, the written agreement requirements of 563 do not apply. Now, you cannot have agreed to represent the buyer either orally or in writing, and you can't be otherwise acting as their agent. And it goes without saying you can't give that buyer any advice or opinions, not only about that property, but about real estate in general. That would give rise to an agency relationship. You would be doing acts of real estate brokerage if you were to advise or give opinions to that buyer. And that would, just under the old rules, under the new rules, give rise to an intermediary relationship. And also, it would trigger the new requirements under 563 to enter into a written agreement with those prospective buyers. So let's just keep this one simple. If you're holding an open house on behalf of your own seller and you have prospective buyers come up to the property that you do not represent, the rules merely require that you let those buyers know that you're holding that open house on behalf of the seller. Now let's look at scenario 2. This is a scenario in which you're holding an open house on behalf of another agent within your brokerage. In that case, the exact same rules as scenario 1 will apply. Why is that? Well, the seller is a client of your broker, not of you individually, and not a client of the other agent individually. So all your fiduciary duties and obligations flow to that seller, and you're there at the open house on the seller's behalf. So under Senate Bill 1968, you have to inform all prospective buyers that come to the open house that you're there representing the seller. You cannot have agreed to represent any of the prospective buyers, either orally or in writing, and you cannot be otherwise acting as their agent at that time. Also, you cannot give those prospective buyers any advice or opinions, and that includes about the property for which you're holding the open house or about real estate in general. If you were to provide any advice or opinions, just like in scenario 1, that would lead to an intermediary relationship that you would have to properly establish under existing rules and also enter into a written agreement under 563 with the new Senate Bill 1968 requirements. So to keep it simple, in the scenario in which you're holding an open house on behalf of another agent within your brokerage, you're there representing the seller and need to inform all prospective buyers that you represent the seller, and you do not need to enter into a written agreement under 563. Okay, the first two examples were pretty simple. We're about to throw a monkey wrench into things with scenario 3. This is a scenario in which you hold an open house on behalf of an agent at a different brokerage. Why does that get so complicated? Let's look at how the situation arises. Normally, it's either you reaching out to the agent at the other brokerage saying, "Can I hold your open house? It's beautiful. I would love to hold it open this weekend." Why did you do that? Most of the time you do that because you want to get buyer leads. You're trying to drum up business and to get buyers by having them walk into this open house and getting introduced to them. The other way that it comes up is when listing brokers or listing agents reach out and say, "I need help holding this open house." There's Facebook groups dedicated to that. And sometimes those listing agents even agree to pay you to hold the open house. Now, the pay is normally nominal, but why are you there to begin with again? And it's the same motivations most of the time as in the other case. You're there to try to get buyers. So why is that complicated? Under the old law, before Senate Bill 1968 came out, you had to represent somebody. You had to represent the buyer or the seller to do any act of real estate brokerage. And holding an open house is an act of real estate brokerage. So in that case, when you agreed to do the open house, clearly you weren't representing buyers. You didn't even know the buyers at that point. So you were representing the seller in holding that open house as a subagent. And all your fiduciary duties flow to that seller. And if that was the case today, the same exact rules that we went over in scenario 1 and 2 would apply. Now, let's pause for a minute and step back. You probably heard the Senate Bill 1968 termed the subagency killer. That subagency is dead and gone. Well, unfortunately, it's not that clear. As much as I disdain subagency and think that it's potentially harmful to consumers and is a misunderstood concept, it's still lurking around here. Senate Bill 1968 removed the term subagency from 2 different sections in TRILA. One of the sections was a definition, and the other was a section that limited liability for a subagent's actions. Senate Bill 1968 did not expressly prohibit subagency. So why do we say earlier that it's practically dead on the buyer side, on the residential buyer side? Well, we have the new written agreement requirement in that case. So you would have a direct agreement with the buyers, and you're no longer a subagent. You're acting directly for that buyer. Well, there is no written agreement for the seller side. So you can find yourself in this scenario and become a subagent even under Senate Bill 1968. So if you agree to hold that open house and don't make it clear with the listing broker or listing agent, or even with the seller, that you're only there with access to the property. You're there because you want to get buyers, you're willing to hold the open house, but you're not representing that seller. You're not agreeing to, then it can give rise to an implied agency relationship. the seller is going to think you're there on their behalf. And so it's best to set it out in writing as clear as possible, both with the listing agent and better yet, even the seller, that you're not there representing the seller. You're merely getting access to the property and that you're there for the purpose of securing buyer leads. How do you create a proper non-representation agreement with a residential buyer at an open house? To do that, we have to look at both sections 562 and 563. When we walk through this, we're assuming you're at the open house as an agent, not as a representative of the seller, that you have not created either an express or an implied agency relationship. You're there with their permission and authority, but you're not representing them. So when a prospective buyer comes to the house, 562 mandates that we have not agreed to represent that buyer either orally or in writing. Similarly, we cannot be otherwise acting as that buyer's agent. The only service that we can provide to the buyer is showing services. We cannot give them any advice or opinions. The only things we can confirm are the price, size, and terms of the real estate that's being offered. When they first arrive to the open house, we have to provide them the IBS. Then we have to have the buyers execute an agreement, a written agreement, that's required under sections 563. Now, remember, 563 only applies to residential real estate. It does not apply to commercial real estate and does not apply to leases. The written agreement is a written agreement required with prospective residential purchasers. 563's requirements fall into two categories, one for representation agreements and one for non-representation agreements. We're going to walk through the non-representation agreements and I'll highlight the differences. The first thing you must state are the services that you're providing and that you're not representing the buyer as the buyer's agent. So in that agreement, you would state that the only services you're providing are showing services. If it was a representation agreement, you could provide the full services, the full broker services that you otherwise could offer. Next, you must state whether the agreement is exclusive or non-exclusive. For non-representation agreements, they must be non-exclusive. You cannot have an exclusive non-representation agreement. You must state the amount and rate of compensation. The requirement in 563 for the amount and rate of compensation is different from the NAR requirement. The NAR requirement is actually more detailed. And so if you're in compliance and are familiar with the NAR requirement, you'll likely be just fine under Texas law. The next one that you must state is a termination date. The termination date for non-representation agreements is limited to no more than 14 days from the date of the agreement. There's no such limitation on the termination date in full representation agreements. Finally, in conspicuous language, you must state that broker compensation is not set by law and is fully negotiable. So if you have are in a situation where you're not representing the client, you haven't agreed to be their agent, you provided the IABS, and you've had the buyer review and sign the written agreement, then you may proceed to show them the house. Now, what happens if the buyer refuses to sign the written agreement? Well, in that case, unfortunately, you may not proceed to show them the property. 563 has an express mandate that you cannot show residential property to buyers without getting that written agreement signed. So in that case, you'll have to explain to them what the state requires and that you cannot proceed to show them the open house. We hope you enjoyed this video and that it answers some of the questions you had about open houses under Senate Bill 1968's new rules. Special Provisions has an entire CE course dedicated to Senate Bill 1968 that goes into more of the nuances in the details and discusses more of the practical and legal implications. We also have many other CE courses, and we hope to see you at one soon. In the meantime, like us on Facebook and subscribe on YouTube, and we look forward to bringing you more videos very soon.